pleasure to meet you.
Yes, please.
நல்ல டைமிங் நம்ம.
Hello everybody. Aloha from Hawaii. I'm Michael Wilson. All theirs. Nice to meet you. I'm Michael Wilson from Hawaii.
I'm Sabrina McKenna from the state of Hawaii. Nice to meet you. Nice to meet you. Hello. How's Sabrina McKenna from
Please come to our
Oh, interesting. Wow.
As a lawyer, he has been audited each case.
Yes, this is yes, not in the name of judges alone, in the name of seniors also, senior advocates. Mr. Public Prosecutor, please come.
Everybody. It's an honor to meet you.
Yes.
I heard you were going to be from Hawaii.
Yes. This is purely, this book is meant for reference only, not for lending.
Okay.
All very old books.
Who would come here to use this?
Yes, our members, daily advocates, our members. This association is having membership of 1,200 advocates. 1,200, all seniors.
Michael Wilson. We just met.
Sir, Mr. D, please come, please come. Sorry that God's meeting I am unable to attend.
Sir, I see.
Yes, in Germany invited, we have extended the invitation. Yes.
Both of them.
Yes.
Westlaw Asia.
Same copy.
I showed it to you. I have one in my office.
You have one of the original. Yes, our court has referred to your court. Have you Article 21 in here? Very important.
I want to tell you something amazing here. This is very important before you see this. So, when our first Prime Minister Nehru, ideally, he should have been asked to sign the Constitution first. But Nehru did not do that. He signed the Constitution first. But since he already said there is no space, you will see this here. It's a very important historical, unprecedented information which I am sharing with you. Nehru signs here, there is no space. Other than Gujarat wasn't signs like this.
Oh my goodness.
It's amazing people too.
The article 21A was added because of but it says protection of life and personal liberty of no person shall be deprived of this shall provide free and compulsory education to all children of the ages 6 to 14 years of
same way, right to livelihood is also
not that
which year old?
shared experience.
அண்ணா
Youngest member. Research work? Yes.
This is very useful, sir. We can take judgments here. Get him and go home. All the journals. Instantly we can take it.
This is
The e-library.
what's that?
The e-library.
E-library, okay.
They can primarily be used for bar benefits, especially the youngers who don't have their own library.
Yeah, I see. Yes, that makes sense.
Like the citations.
Who can use this?
And anyone can come in, or has to be a member of the bar?
Only
Member of your bar. Okay. Very nice.
Otherwise, otherwise it will be overcrowded.
That's true.
அண்ணா ஃபீல்டு பின்னாடி வாங்க ரமேஷ் எனக்கு தெரியாது எனக்கு தெரியாது
bit disappointed. Because he had planned to come.
Yeah, whatever, but because of this.
We totally agree. I know. Yes.
இங்கே போட்டோ எடுத்துலாமா
Justice Sundar Kumar, former judge of the Supreme Court. They are all the
Mr. Chief Justice, I want to tell you that we were in the Bombay High Court and everybody told us that you would do 200 plus cases on a day-to-day basis. Everybody remembers that.
That's more than that here also. Yes.
Why don't you quickly introduce yourself so that before we go to the other?
My sister is also Asha,
Jenny, you can start.
Justice P.T. Asha.
I'm Bhavani. Jenny Rivera. I sit on the New York State Court of Appeals, which is our highest court. Happy to be. Okay.
Hi, I'm Sabrina McKenna. I'm a justice of the Supreme Court of the state of Hawaii.
Aloha, I'm Michael Wilson. I just retired about 2 months ago from the Supreme Court, so I'm colleagues with Sabrina and Justice Todd Evans, and I'm kind of an India wannabe.
It's a pleasure having all of you here.
Wonderful to be here. Please come.
School of Law at the University of Hawaii. Good afternoon, my name is Ann Aiken. I'm a U.S. District Court Judge in Oregon.
Hi, I'm Todd Evans. I'm a justice with the Hawaii Supreme Court.
Hi, I'm Sarah Ellis, and I'm a federal district court judge in Illinois. I sit in Chicago.
Aloha from Hawaii. Pleasure. Namaste. Hello. Nice to see you. Oh my goodness. It's an honor. Michael Wilson from Hawaii. Pleasure to meet you. Yes, it's great to have everybody here. Aloha.
Hi, I'm Sabrina McKenna from the Supreme Court of Hawaii. Nice to meet you. Sabrina McKenna from the Supreme Court of Hawaii. Nice to meet you. Nice to meet you. Are you senior advocate?
Yes. I'm Los
Oh, such an honor. Thank you so much.
Hello.
Hello.
Are we supposed to?
Yes.
Nice to meet you. Nice to meet you. I'm Justice Mandela.
Nice to meet you.
Los Angeles. I'm Justice Mandela.
Pleasure, Michael Wilson.
Yeah, Judge. I go to Mandela.
Oh, it's an
How
honor.
is it feeling? Everything's comfortable here?
Wonderful.
Yeah.
We're very excited to be here.
Hello. Hello. Sabrina McKenna from the nice meeting you. From the Supreme Court. And this is right, right.
Earlier, but there were some circumstances beyond our control, and let me begin by first acknowledging that it's a difficult sort of day for many people here, and we thank you for being here and being patient, but it's also an extraordinary honor and privilege to host this group of judges, jurists and academics from India and the United States. let me start by first saying that, what binds us together across the Indian and the American jurisdictions is far more than what separates us in these two jurisdictions. And something when I was reading as a student to look at how the United States Constitution was first put together took me back to the founding ideas of political equality, natural justice, and the sovereignty of the person. And I remember that when Jefferson first wrote these words, he wrote these three ideas to be sacred and undeniable. But when Franklin took over, he changed it to say that these ideas are inherent and self-evident. I think that debate, like many even in the Indian Constitution, continues till date. What is the right words? And though we are lawyers and we like to fight over words, I think having this sort of cross-section of jurists and academics is a great privilege. So thank you all for coming to the Madras Bar Association's event at the Madras High Court. So with that, I would like to request the President of the Madras Bar Association, Mr. Kamal Nathan, to offer his welcome remarks.
Honorable Justice R.N. Manjula, Judge High Court of Madras, Justice Sudhandra Kumar, former Judge Supreme Court of India and former Chairman National Green Tribunal, Senior Advocate Mr. R. Shanmugasundaram, Advocate General of State of Tamil Nadu, the judges and jurists from the United States of America, respected senior advocates, my dear friends of the bar, good afternoon to one and all. Today, when this meeting is being proposed, the Bar Association always, Madras Bar Association always in the front runner to invite the foreign delegates, jurists, judges from all over the country. Immediately we have arranged this program in coordination with the Advocate General Mr. R. Shanmugasundaram, State of Tamil Nadu. Today's topic is the role of judiciary in protecting the rule of law and promoting access to justice. Due to unprecedented reasons, this program is being shortened, and due to paucity of time, now it's almost 2:20. We have to cut short the programs. The interactive session and seminar is going to be conducted in a very crisp manner, taking into consideration of time. I welcome first I will introduce the judges and jurists. Honorable Mr. Justice Michael Wilson, former Judge Supreme Court of Hawaii. Sir, please stand and just. Honorable Ms. Justice Sabrina S. McKenna, Judge Supreme Court of Hawaii. Honorable Mr. Justice Todd W. Edins, Judge Supreme Court of Hawaii. Honorable Ms. Justice Anne Akin, Chief Justice, U.S. District Court of Jenny Rivera, Associate Judge, New York State Court of Appeals. Justice Sarah L. Ellis, Judge, District Court of Northern District. Josephine L. Station, Judge, U.S. District Court. Professor Camille Nelson, Dean William Richardson Law School of Law. Douglas L. Toki, Judge, Court of Appeals. Andre Bairotti, Judge, U.S. District Court. And Justice Sudhandra Kumar, you all know, everybody knows about Justice Sudhandra Kumar, former Judge of Supreme Court. And Mr. Raj Kumar, who is the key person of the Jindal University. With this, I extend our warm welcome to all the dignitaries for this great session. And I wish this program will be very useful to all the advocate fraternities. Thank you.
Before we begin the interactive session, we request the dignitaries to be honored by our members of the Madras Bar and the Judiciary. May I please request Honorable Justice R.N. Manjula to honor Justice Swatantra Kumar. Thank you. May I also request Justice R.N. Manjula to honor Justice Michael Wilson, please, of the Supreme Court of Hawaii. May I request Senior Advocate Mr. Ravindran to honor Justice Sabrina McKenna, please. May I request Advocate General R. Shanmugasundaram to honor Honorable Mr. Justice Todd W. Edens, please. May I request Senior Mr. V. Chandrakandan to honor Honorable Justice Anne L. Aiken, please. May I request Senior Advocate K. Srinivasan to honor Honorable Justice Jenny Rivera, please. May I request Senior Advocate M.S. Subramaniam to honor Honorable Ms. Justice Sarah L. Ellis, please. I request Advocate Rita Chandrasekhar to honor Honorable Justice Josephine L. Staton. Srini, yes. May I request President MBA to honor Honorable Justice Douglas L. Tukey, please. May I request Secretary, Madras Bar Association to honor Honorable Mr. Justice Andre Birod Jr., please. May I request Treasurer, Madras Bar Association to honor Professor Camille Nelson, please. May I request Librarian, Madras Bar Association to honor the Honorable Justice R.N. Manjula, please. May I please request May I request Advocate Hemalata to honor Professor Dr. C. Rajkumar, Vice Chancellor, O.P. Jindal, please. Thank you very much for your patience again. Now we move on to the interactive session. With that, may I please request Honorable Justice R.N. Manjula to provide us with the special address for this occasion.
Kumar, former judge, Supreme Court of India, distinguished jurist, professor of law and justice, Jindal Global Law School, and the honorable visiting judges and jurists of United States and India, and the respected members of the bar. Good afternoon to everyone. It gives me immense pleasure to be the part of this interactive session. But I would say that I am only a substitution. My brother Justice Suresh Kumar is actually planned to come. The pleasure for being the part of this function is primarily due to the similarities between India and United States. We are two largest democracies and who have the large living democracy. Though we are the longest democracies, India has got largest population and we are largest in that sense. Previously, when there is the rule of king was in force, whatever the king said is the law. During the year 12th century, the rule of king has transformed into the rule of people in a way that rule of law came into existence by the promulgation of Magna Carta in the United Kingdom. Following that, Bill of Rights in US, and then the Constitution of America, and we adopted the Constitution in the year 1949, 26th November, and thereafter the Constitution came into effect on 26th January 1950. So what is the significant aspect of all these bills and the enactments is that even if he is a king, he is a subject of law. So everyone is equal before law and no one is superior. And our role as judges in protecting the Constitution has already been guaranteed in our Constitution itself. We have the powers of review by a writ jurisdiction under Article 32 and 226. Under Article 32, Supreme Court has got that power of review, and 226, the High Court has got jurisdiction. And one of the similarities between US and Indian Constitution is that we adopt federal form of the administration. And our government and the US government, we have fundamental rights as one of it is the heart of the Constitution. We have fundamental rights, and any law which is contrary to the principles of the fundamental rights will be declared as unconstitutional. And we have even given new breath to the Article 21, which is the fundamental right to life and liberty, by holding that life and liberty has got too many facets. It is not only a person's personal liberty, but also the quality of living. So if a person it is not a mere vegetative existence we would like to save and under the fundamental rights, but the quality of life. The right to dignity is also a part of fundamental right. So the various judgments of the Supreme Court and High Court, we have given life to our Constitution, and sometimes even expanding the scope of fundamental rights. Like as I said, that the right to life is, now recently the Supreme Court has held that right to privacy should also be viewed as a part of the right to life. So various, and this is the judicial activism that has been developed in 1980s by way of public interest litigation has also promoted and protected the rule of law in India. While coming to access to justice, by access to justice we mean, it is not the access to justice which people who can afford to spend on litigations. So when we call everyone as equal before law, the opportunity to have access should be available to all, irrespective of their economical and social status. So we adopted as the legal aid, free legal aid through state, as one of the right of parties, and that is how we protect the level playing field between the weaker and the stronger. And sometimes, and many times, when the state happens to be the adversary, and there is adversarial litigation between the state and an individual should not be deprived, and individual should not be allowed to feel insecure, and that is why we are robustly encouraging free legal aid to be given to people whoever deserves and whoever wishes to avail the opportunity at the cost of the state. And access to justice would mean not only availability, but also the accessibility in terms of real access. Because we are diverse, we are a country which have diverse population and diverse culture. And so, it is our economical status is also unequal. So every person who either educated or uneducated or whoever is able to afford to fight his right in the court of law or not. See, we have to give access to everyone, like we have increased the number of courts given the geographical location and in accordance with the population. And gender justice also, we guarantee gender justice also under Article 14 and 15 of our Constitution. So no discrimination can be done on whatever basis, whether it is on sex or any other parameters. So with this, and one more thing, after this COVID time, we had invented a kind of access through video conference. So people needed to file their litigation through online mode itself, and the access to justice has evolved one step further so as to give access, even if someone is at some remote point, he can also have access to justice. So with these opening remarks, I would I would open the floor for discussion. Thank you so much. And I have the pleasure of welcoming you all. Welcome you all and enjoy the session. Thank you.
Thank you very much, Justice Arun Manjula. As lawyers, we are always demanding a lot from our judges, so we appreciate your time here during lunch and for offering your remarks and setting the context for the discussion. May I now please invite Honorable Mr. Justice Swatantra Kumar to offer some remarks towards this keynote of this interactive session.
Good afternoon to all of you. Honorable Justice Manjula, Mr. Advocate General, President of the Bar, Office Bearer of the Madras Bar Association, learned senior advocates, and the advocates of the Madras Bar Association. It's not often that judges speak before lawyers. It's always the converse which is true. I saw Justice Manjula, you saw at the end, she started feeling cough because I'm sure she felt the audience was a little too bright for our liking. Anyway, that's on the lighter side of the rule of law which we talk about. But before I start, I would like to share something very, very personal and very, kind of a very nice memory of my professional life. It was somewhere in the late 70s. I had come to argue a matter in Madras High Court. I still remember that court of the Honorable Judge was on the ground floor. I was a counsel for the Central Pollution Control Board. I was the standing counsel. So the Pondicherry paper mills case was to be argued. And I still don't forget the Honorable Judge was quite tough. And that's the day I made up my mind that if I'm going to be judge, I'm going to be a tough judge. So that was my first experience in this court. But luckily, for God's grace, I could succeed in that case, and Pondicherry Mills was directed to be closed. So I have a very sweet memory of this court, and definitely one cannot ignore the fact that this bar has given fabulous judges to the Supreme Court of India and few very eminent lawyers like Mr. Prasran, like others who was, it was great to see those eminent personalities from this part, or this state particularly, who led the front of the legal profession for a considerable time. So my heartiest congratulations to this bar, and I hope you continue with the high tradition of your bar. Coming to the rule of law, if you see our Article 12, why would the Constitution framers use the expression equality before law and equal protection of law? What is the fine distinction that has been drawn between these two expressions is exactly what is rule of law. Rule of law is not a mere formality to be performed by stakeholders of the state, but it's a reality to be established that the last man in the queue, the poorest section of the society or the country, is able to get easy access to justice. And justice is primarily where the people of the country feel confident that they will get justice, not for the name's sake, but in substance they will be able to get justice. And that hope In the words of Justice Kapadia, the former Chief Justice of India, was the judicial confidence of the people in the court. So if the people have that confidence that the judicial administration of a country is so firm, so accessible, that whatever be the situation, you will get justice. As all of you know, even fundamental rights are subject to suspension during emergency. But there are rights which are untouchable, which even prevail under 226 during that period. So if the framers of the Constitution in our country provided a very optimistic system for administration of justice to ensure that the people do not feel left out, no matter which section of the society they belong to. So equality, if you look at our preamble of the Constitution, it talks of social, economic and political justice. Therefore, the expression justice has not been confined to merely pronouncing judicial judgments. It is an onerous burden placed upon three organs of the state, which they must ensure to provide the social, economic and political justice. Once you are able to provide all three sections of this concept of justice, the rule of law will prevail. Rule of law is not a domestic subject in the present times. It is a concept of global magnitude. Whichever country you talk about, the rule of law is the first issue that is put up before any governing body to ensure that the rule of law sustains and it does not frustrate the very purpose of our existence. Because if there is no rule of law, everything is bound to fall into a mess. Whatever it may be, it may lead to conflicts, it may lead to wars, it may lead to any kind of national or international variations of process of thinking and administration. But the prime ground is that one should be able to ensure that is and I have no hesitation in saying, everybody talks of arrears in Indian courts. That's the biggest obstacle or impediment or adverse comment that is put on the Indian judicial forums for the purposes, but nobody really rationalizes it. I think heavy pendency before the court itself shows the confidence of the people of India in the judicial system. If there were no people who believe that they will get justice, why would they go to courts? They'll sit home, they break head of each other and finish it off. There will be other forums, other processes which will resolve the disputes. People will not. We are the most highly populated country in the world. You have to think of judge-case ratio. You know of the ratio of a nurses versus patient, students versus teacher. You know doctors versus analysis. But nobody thinks of a judge-case ratio. If somebody thinks, the Law Commission of India once gave one judge is to 1,200 cases in the trial courts. And our ratio is 1 is to 10,000. Kindly imagine that. So it is not something. I think it's a compliment to the system that people have so much of faith in the judiciary and they believe that rule of law prevails in this country and is administered properly. Thank you, ladies and gentlemen.
Thank you very much, Honorable Mr. Justice Swatendra Kumar, for your remarks and for explaining the various facets of justice and the responsibilities placed on the various parts of the government in delivering comprehensive justice. May I now please request the Advocate General of Tamil Nadu to offer a few remarks to the gathering, and then I will request Professor Vice Chancellor Dr. C. Rajkumar to also address the gathering.
Welcome, honorable visitors. I'm a very surprise addition in this panel, and I'm asked to talk without a brief and without fees, unpaid, without fees. And suddenly 2 minutes back I was asked to, and I'm happy to be associated with this team of visitors, honorable members of the judiciary from United States of America. I really know nothing about the system in America. I only know that we are following the British system, and totally contrary to what you practice in the United States. Of course, we both have the adversarial system, unlike the European, which is an inquisitorial system. And that is the basic thing I know. But what I would love to know and appreciate is, you have in criminal law, I am basically a criminal lawyer. In criminal law, you have the plea bargaining. That we have been contemplating for so many years here. We wanted to introduce long back at various stages. Even about 10 years back it was attempted, but that is not coming to effect. That is one aspect I love, and if you want to tell us about that in detail, we will all be happy to know this. And about Constitution, Honorable Justice Swatantra Kumar said beautifully, and Honorable Justice Manjula also spoke nicely on this. That is the outline of the Constitution we have. That is the basic system we follow. With these words, I thank you very much for the organizers to making me present my remarks also to you. Thank you very much.
Thank you very much, sir. And with that, I would like to invite Professor Dr. C. Rajkumar, who has a connection to Chennai. He was a student of Loyola before he went to smaller universities like Oxford and Harvard. And then he's come back to now lead the O.P. Jindal Global Law University, which he was appointed as Vice Chancellor at the age of 34. So he's been Vice Chancellor for now 4 years?
15th year as Vice Chancellor. So, well, thank you very much. It's such a pleasure to be here back again at the Madras Bar Association. It's my second time to be here, so I want to first of all extend my heartiest greetings and congratulations to the Madras Bar Association, but also its President and Secretary and other office bearers. I also want to thank the Honorable Advocate General for his presence and his comments. I think it is only fair to say that we have an outstanding Advocate General who represents the progressive side of the bar, and I'm grateful to him for his time and his presence here. Of course, I'm grateful to Honorable Mr. Justice Swatantra Kumar, not only for being a distinguished judge and his contribution to the National Green Tribunal, but he also influenced and inspired the American imagination for environmental litigation as well as matters related to tribunal, which my friend Honorable Mr. Justice Michael Wilson will briefly reflect after I speak. I just want to take this moment that the the group of 10 judges and jurists who have come from the United States represent 5 different states of US. They are from the state of California, the state of Hawaii, the state of Illinois, the state of New York, as well as the state of Oregon. They represent the different levels of the judiciary there, including the state court, the Supreme Court, as well as the federal district court. And also, we have a distinguished academic from the University of Hawaii Law School, the dean of that law school. So it's a very eclectic group of individuals who had vast experience of advancing the cause of rule of law and justice. This journey that we have undertaken from Delhi and going through Mumbai and engaging with lawyers and judges at the Bombay High Court, and then here at Madras, and then tomorrow at the Karnataka High Court, followed by the culmination of our visit at the Kerala High Court, is an effort to understand the Indian legal system, Indian judiciary, Indian judicial process, Indian legal profession, and of course, Indian legal education. So we are very, very delighted that we are here. We were hosted earlier by the Honorable Chief Justice of the Madras High Court and had a brief interaction with the distinguished judges here. And I am truly grateful to the Madras Bar Association for giving this opportunity to greet all of you and to have an opportunity for our distinguished visitors to have a sense of this illustrious bar and its contribution towards advancing justice. With those words, I once again want to thank you for this opportunity.
Thank you, Professor. It would be a privilege to make all of you stay longer and hear every one of you. I note that one of the leading landmark cases from the Hawaii Supreme Court, in reference Hawaii Electric Company, was authored by 3 of the justices who are present with us. But in the interest of time and in the interest that you will get more time outside of these premises in seeing our lovely city of Chennai, may I please only invite Honorable Mr. Justice Michael Wilson to say a few words on behalf of the entire delegation.
Hawaii, that is the word that we use in Hawaii to recognize the beauty and the human spirit, and it's like namaste. And since great Justice Swatantra Kumar, who's been a great friend to Hawaii, mentioned something personal, let me ask your indulgence, Mr. Senior Advocate, and ask the indulgence of our assembled group to say that my life was saved in Tamil Nadu and in Kerala. And it reflects to some extent, when I look at this audience and I think about India, the courage that reflects to a certain extent our relationship between the United States and India. Because when I first came to India, of course it's this giant, we have 1.4 million people, you have 1.4 billion people, we have, you have as many lawyers as we have citizens. So when I came, it was an extraordinary opportunity, and my brother, Vice Chancellor Kumar, had worked it out so that I could find a tiger. A tiger is my favorite animal in the world. I went to Perrier. I was with a very noble naturalist, a follower of Druga, who was helping me find the tiger. We were in the forest, and we got charged by an elephant. The elephant was running at me, and he said, "Run." And the kind of courage that I thought he was showing, since, there was an elephant running and he was trying to protect me, definitely was on my mind. I gave him my jacket. It was blue. A blue jacket, apparently, don't ever wear it. It's what gets the elephant upset. And he ran off with the jacket going like this to the elephant. The elephant followed him. And then I thought, man, people from Kerala or Tamil Nadu are so brave. And then the next thing I know, I was actually here for a conference that Justice Kumar had really, he was the originator of for judges from around the world. And then Justice Thakur spoke, the Chief Justice of India. He was so powerful. And then I see Raj Kumar develop a law school in 10 years with the kind of courage to speak truth to authority, he says. Then our court, working closely with the court, the Supreme Court, and with this memory of Kerala, working closely with your court, we developed Manu mentioned a case. This case is something that arose in part because of our relationship with you and the kind of commitment that is a commitment that goes beyond just commercial when it comes to nature. We're pretty much devoted to commercial in Hawaii, and it goes to the idea of protecting nature, because you look at what you've done with Article 21, you look at the cases that have talked about the right to a clean and healthy environment. It's moving in a beautiful direction. You know, it makes sense that if we've got the worst environmental problems we've ever had with climate change, where 100 million people are going to have to leave Bangladesh and head towards India with the next 30 or 40 years, where you've got the Secretary General of the United Nations saying that we're on the highway to climate hell with our foot on the accelerator. Thank goodness for the jurisprudence of India that reflects this kind of power of Kerala, Tamil Nadu, the connection to nature. All of this is taking place. It's exciting for us. And then we look at our Supreme Court that's going in the opposite direction. So I'll conclude by saying thank you for being so courageous. And I confess, I'm probably overly idealized. I think of all of you kind of like Rajneesh, who saved my life, or Raj, who put together this institution devoted to integrity in government. But you make a big difference to us, and this is a historic thing for our brothers and sisters on the state court and the federal court to be with you, the brothers and sisters that are from a big place. It's even a more giant political system, with a Supreme Court, you might say, that's even under more pressure than ours, but a Supreme Court that seems to distinguish itself with the kind of values that come from Kerala, Tamil Nadu, and courage to stand up to the trend that might be there to not pay attention to access to justice. Our Supreme Court moves us more towards limiting access to justice, where you've got the kind of access that's extraordinary, where a citizen, as Justice Kumar says, that needs justice can come to court and get it even without a lawyer, even going to the Supreme Court. And where the young people, and you have 444 million, the young people that are most at risk in the world have young lawyers, committed judges who recognize the law has to evolve to protect them and their rights to a life-sustaining climate. Aloha, thank you for the opportunity to address you, and thank you for representing courage and justice for all of us. Appreciate it.
Thank you very much, Justice Michael Wilson, for your courageous words and words of true encouragement. Can I request the Secretary to deliver the vote of thanks?
Honorable Justice. Yeah, please.
There's a few minutes I would like to address the issue of access to justice. Thank you. My name is Sabrina McKenna. I'm a Justice of the Hawaii Supreme Court. I served with Mike Wilson, Todd Edens. I'm from Japan. I was a trial judge before I became a Supreme Court Justice. And I wanted to address issues regarding access to justice. First, the issue of plea bargaining, the question that was asked. One thing I want to make clear that there are different systems between the federal courts and the state courts. Each state in the United States has its own constitution. State courts are free to give greater rights under the state constitutions than are provided under the United States, by the United States Supreme Court. And that is a good thing now that the United States Supreme Court is now withholding and taking away rights that previously existed. State courts and federal courts differ. Federal courts, judges cannot participate in plea bargaining. In state courts, it depends on the state. In Hawaii, we can and we do. Judges will speak to both lawyers at once and talk, and they'll explain what the charges were, what the potential sentences are, and ask if the judge would be willing to impose probation or a shorter jail sentence, etc. And the judge can say, I will be bound by, I will impose probation. But at the time of sentencing, if there was too much, the judge feels that it's not appropriate, then based on a judgment that I wrote a couple years ago, the defendant in Hawaii is entitled to withdraw the plea of guilty. And so the case starts anew. And that's a due process issue. And so the state courts are trying to, and the various courts try to do a lot for access to justice. We have access to justice rooms at every trial court where we have lawyers, volunteer lawyers that provide services. We also have I'm sorry, how much time do we have? Okay, thank you. All right, so one important thing is that in all federal courts and in most state courts, including Hawaii, all court filings are online, so anyone can access the court filings all online, which makes a big difference. And in Hawaii, we have access to justice rooms. In every trial court, volunteer lawyers will provide legal information services. Now, of course, all criminal defendants with a possible jail sentence of 6 months or more under the federal constitution are entitled to counsel, attorneys. If you are indigent, the government will provide lawyers in a criminal charge, but that does not apply to civil cases. The only cases under Hawaii law in which we have a right to counsel in civil cases is where there is a potential that rights of a parent will be terminated because of neglect or abuse. The government can take away parental rights if the parent is abusing or neglecting their child. If that is a potential, the parent is entitled to a lawyer because the parental rights are considered fundamental rights under the United States and many state constitutions. Zoom has really helped. We now have a lot of Zoom hearings. A lot of courts are deciding which proceedings will continue with Zoom. It's created much more access to justice, but the problem is the digital divide. Some people don't have internet access. So for example, in Hawaii, we now, anyone can come to our Supreme Court Law Library and access Zoom proceedings anywhere in the state, and the law librarians will assist. Our law libraries also provide free access to Internet Westlaw, which is our e-legal research. So pro se, self-represented people can come to our law library, and the law librarian will help them research the law. For small claims cases, the court personnel will help all the people fill out the forms, and we have people that help people fill out the forms if they are self-represented in small claims court, district court, and in family court. Obviously, language access is a huge issue anywhere, especially in India. Under Hawaii law, we provide free interpreters. Sometimes we use telephonic interpretation for all participants in our courts, over the counter, all witnesses, all parties, all free language access services. That's a given. That's not true in all states. And it's also not necessarily true in federal court, right? Because the only right is when the United States government is the plaintiff. And like in immigration court, you will see interpreters appearing telephonically to help interpret for the judge. But I have seen situations where the immigrant cannot communicate with the lawyer in court because there's no interpreter to help them interpret. But that's not true in Hawaii. We provide an interpreter for the litigants as well as for the witness that's on the stand. So we will have separate interpreters many times. Our ADR system is very well developed. In Hawaii, in 1980s, we've had a Center for Alternative Dispute Resolution. In almost all cases, there will be mediations, private mediations, or through the neighborhood mediation centers, or judges themselves are trained and will conduct settlement conferences, and we will settle cases ourselves. So there are actually very few civil trials because almost all cases are actually settled by judges or private mediators or neighborhood mediation centers. And let's see, and like in family court, we have volunteer lawyers that are sitting outside on certain days that help parties. These are very experienced family law advocates that will help the parties settle the cases. In court, a lot of times we have self-represented litigants, and we will, I was not a popular trial court judge for lawyers because if one side was represented and the other side did not have a lawyer, and the lawyer would say, objection, I would say, all right, let's lay the foundation. And I would ask the questions to lay the foundation, and I would receive the evidence. And the lawyers would complain, say, no, this is supposed to be an adversarial system. I said, no, this is a system to achieve justice and to get to the truth of the matter, not to allow people that are not represented to not have their day in court. And so as a family, I was a family court judge also, so a lot of times both sides were unrepresented. And I say, okay, what's this case about? And then, I would just ask the questions, receive the evidence, and then make my judgment. Let's see. We also have rules that allow pilot projects to allow non-attorneys to assist people, especially in family court or landlord-tenant cases. We just expanded our law student practice rules so that law students can practice law in the courts under the supervision of a lawyer without the lawyer being present, and that is to increase access to justice. So there are different things going on in different jurisdictions to increase access to justice. But I would say that, one of the main things that we need is what we call a civil Gideon, which is the right to counsel in all civil matters also, because we have right to counsel in criminal cases, but not in all civil cases. And it's only the rich people or the poor people through legal aid that can have lawyers, and in the middle class cannot afford a lawyer. I couldn't afford a lawyer in a civil case with my judge's salary. I couldn't do it. And so, of course, I would have to represent myself, I guess, or have a friend represent me if I ever had a civil case. I haven't. So that's good. But finally, I just want to end with the concept of the rule of law. I want to talk about the rule of law. What is the rule of law? We've talked about it. One of the things that was talked about was there's an organization called the World Justice Project that talks about the 4 principles of the rule of law. The first is accountability. All actors, government and private, are accountable under the law. The second is open government. Government must be open and transparent. The third is the laws must be just. The laws must be just and fair to everyone, and that includes, to me, that's the concept of access to justice. The fourth principle is accessible and impartial justice. Neutrals, courts, must have competent and ethical judges that have the adequate resources and represent the communities they serve. In other words, the idea of the rule of law requires a diverse judiciary. I think that it's really important for a judiciary to be diverse because that is how access to justice is increased. Because when you have people that come from the communities that understand the needs of those communities, then systems improve. Domestic violence was not really addressed by United States courts until women started entering the legal profession. That's when domestic violence started being treated seriously. Our access to justice rooms opened because women lawyers and judges said we need to provide more access to justice to the litigants that appear in district, our minor cases, as well as in family court. And so I am here to suggest that I really hope. I mentioned that I was a trial court judge before I was appointed to the Hawaii Supreme Court. It's very common in the United States for what you call district court or sessions judges to be promoted to the appellate courts, the high courts, right? It's very, very common. But I understand that it's not that common and a lot of high court judges, Supreme Court justices, come from senior advocates or advocates. I think it's really important that you diversify the judiciary. I understand that there's a lot more women in your district courts, perhaps, but I think you need more diversity in your judiciary. You have a wonderful independent judiciary, but I think your judiciary would become even better if you diversified your judiciary. Thank you.
Thank you so much. May I please invite the Secretary to deliver the vote of thanks?
And let me just say, I want to say Nandi, for thank you so much for accepting and welcoming all of us. Aloha and namaste.
Respected President, Honorable Justice Manjula, Honorable Justice Sondra Kumar, the visiting delegation from Hawaii and other parts of the United States, Mr. Advocate General, Mr. Rajkumar, Vice Chancellor, past presidents of MBA, respected senior advocates, and my dear friends. It is with immense pleasure that I propose a vote of thanks to Honorable Justice Manjula and the other judges for their visit to the Madras Bar Association to attend this seminar in such a short notice. A special thanks to the Jindal University, especially its Vice Chancellor, Mr. Rajkumar, who has brought this delegation to our Honorable High Court. To the members of the visiting delegation, let me inform you, this is one of the 3 high courts which was established by the Charter of Queen Victoria way back in 1862. So our high court is more than 150 years old. You could visit few more places inside the high court before leaving. For example, we have a museum, high court museum is there, and then we have a lighthouse. So before leaving this campus, you can visit these 2 places. I also have much pleasure in thanking the entire committee of the Madras Bar Association, who within a short notice made it up for this meeting, and also the staff of the Madras Bar Association, the registry, and the members who came to attend this meeting in such a short notice. Thank you very much. Thank you one and all.
Thank you everyone for your time. With that, we close today's meeting.
If there's anything, thank you. Thank you very much. Any questions that we, yes, absolutely. Any questions that we might be able to answer? Thank you, absolutely. I really wish you could have heard from Justice Todd, expert in
We have made all the decisions.
This is oh, good. Thank you.
That was good.
Thank you very much.
You were the first one. Thank you so much. You were the first one.